Adele, any announcements from your side?
No, I'm good.
Okay, I
you
see
have
you've started recording the session for us.
Yes, I have just done that.
Okay.
And have you got a schedule ready for us for next week, or is it as your per your usual schedule?
On students writing next week, students are starting to write next week.
That's
so,
right. Let's
So,
just see. What is this module's exam date? Let me just see.
Michelle,
The
just
1st
give
of
us
December.
the exam date for ILW. Is it the 1st of December?
Yes.
So the 1st of December
Monday.
is on a Monday, yes.
So is this your last class, or are they having another session with you?
I'm having another session on ILW on Saturday.
Okay.
Let me just give you the exact time. ILW Saturday from 1 p.m. until 3 p.m.
Oh,
Remember, that
yes, I've
session
scheduled it.
includes an hour on referencing and plagiarism.
Correct, Owen, it's already scheduled. I just see.
Perfect. So
Okay.
what I will do from tomorrow is I'll have individual consultation sessions during Saturday and possibly on Sunday if students do require.
Perfect. Thank you, Owen.
Okay, Adele, you have a good evening. Thank you so much for the support.
Pleasure.
Okay, students, I've just spoken to Adele. I'm about ready for our ILW session tonight. Let's just give about a few more minutes, let's say 5 minutes, for more students to start. Then I will start in 5 minutes time. Okay, students, you get your notes out for me so long, and any questions you need to pose during the session. Okay, students, let's start. Please ensure that all of your mics are on mute. Okay, students, please ensure that all of your mics are on mute. The session is being recorded by Ms. Blacker from UNISA, and I will request Ms. Blacker to put the links for all of the recordings into the session today and on Saturday so that you are able to access it. Okay. Students, before I start, remember on Monday when I had this session, I had an urgent phone call from work, so I had to attend to a work thing, so I had to stop. So I'd like us to start on paragraph 7.4 on the topic of transformative constitutionalism. Sipe, please switch off your mic. If you don't have a question, please switch off your mic. Okay, so are there any questions before I start? Any questions before I start? Any questions before I start?
Good evening, Advocate.
Michelle.
Yes, sorry, I'm not sure if this is a SEL question or ILW question, but I wanted to ask you, when in the precedent system, would the lower court or the lower high court, like the South High Court in Gauteng, be binding, or would the decisions of the North High Court be binding on the South High Court in the same province?
No. Okay.
No.
So if the High Court in Pretoria
Yes.
makes a decision,
Yes.
okay, that decision is only binding on the courts that fall within the jurisdiction of the Pretoria High Court. Okay? On other courts, okay, it's a source of persuasive value. Okay? Unless, okay, very, very importantly, Michelle, unless that particular High Court made a judgment on a constitutional issue. Okay? Once a High Court makes a judgment on a constitutional issue, okay, that judgment must be confirmed by the Constitutional Court before it's binding on all other courts. If it's not confirmed by the Constitutional Court, okay, it's only binding on the courts, the lower courts, which are the magistrates' courts, which fall within the jurisdiction of that particular High Court.
So that,
okay,
there's some
noise. There's some noise by your way, Michelle.
Yes, it's a very
Okay, it's gone
the
now.
road's
It's
very
gone now.
busy. Yeah. Okay.
It's gone
All
now.
right. Thanks very
Does
much.
it make sense? Does it make sense?
Yes, I think
Okay.
so. So yeah. Okay. Thanks very much.
Okay. Students, any other questions? Any other questions before I start? Okay, there's a announcement from Ms. Blacker again. Those of you who joined, please put your student numbers into the chat. Okay, so if there's no other questions, I'm going to start on page 162, paragraph 7.4, Transformative Constitutionalism. Okay, all of you get there, please. Okay, students. So, as I spoke about on Tuesday evening, I think it was Monday evening, okay, I said that one of the aims, one of the primary aims of our Constitution, okay, remember we're more than 25 years into our democracy now, and still those aims remain the same. So, one of the most important aims of our Constitution is to address the social and economic injustices of the past. Okay, you can still see today. Okay, as lawyers and as law scholars, you need to look at society through a different lens. Okay, and one of the most important achievements for me as a lawyer is that when I chose to study law, okay, I really told myself, and one of my goals was to use my degree and to use my expertise to effect change in people's lives. Okay, and fortunately for me, okay, my qualification has helped me to do that. So we have not many lawyers that practice law in the field of human rights law. Okay, so that has been a very fulfilling and rewarding aspect for me about my career. Okay, and if you view our society, okay, through the lens or through the perspective of human rights law, okay, you will see how unequal our society still is today. The disparities between those who have and those who have not. Okay. And our law, okay, can make change in terms of that. So, one of the most important aims of our Constitution was and is still to address social and economic injustices, especially of the past. Okay, therefore, for this reason, our Constitution is characterized as a transformative Constitution. So, if a question is posed to you, students, if a question is posed to you, wanting to know why our Constitution is transformative in nature, your answer must be that the aims of the Constitution is to address social and economic injustices of the past. Okay? Hence, or therefore, the concept of transformative constitutionalism means that the Constitution drives the process of social and economic transformation by making provision for measures to address the injustices and inequalities of the past. Okay? So, some of these measures include affirmative action, the protection of socio-economic rights, and the prohibition of unfair discrimination. And very, very importantly, please know this in terms of our interim constitution of 1993, okay? Because our interim constitution illustrated the transformative role of our constitution by stating the following, okay? That the constitution provides very, very importantly an, the a historic bridge between our past, okay, and okay, I'm going to come to that point now. Between the past and those of you who know about our past, okay, those of you who know about our past knows that our past was characterized by a deeply divided society, okay, a society characterized by strife, conflict, untold suffering, and injustice. And our Constitution is striving, the 93 Constitution, okay, was striving for a future founded firstly and foremostly because this you can find in the founding provisions of our current constitution, our 1996 constitution, okay, section 1, okay, where it states that it's founded on the recognition of human rights, democracy, and peaceful coexistence and development for all South Africans, irrespective of color, race, class, belief, or sex. Okay? And very, very importantly, you can highlight what I'm going to read now. It tells you, although this metaphor, okay, the metaphor that is used, the bridge between the past and the present, although this has not been included in the 1996 Constitution, okay, it describes appropriately the transformative aim of the current Constitution, specifically the Bill of Rights. Okay, because what this metaphor starts with, okay, is a future founded on the recognition of human rights. And we know our 1996 Constitution, in terms of Chapter 2, has a whole chapter dedicated to fundamental human rights. Okay, where it puts a positive duty on the state, okay, to protect, okay, those human rights. Any questions for me so far, students? Any questions for me so far? Tumisani, we on page 162. Yeah? Page 162. Okay, there's no questions, so I will continue. Okay, there's no questions, so I will continue. We currently have about 20 people in the meeting. Even Apples, are you new? Even Apples, are you new? You don't have to speak to me, just indicate in the chat function yes or no. Okay, that's the only strange name I see. Further on, I recognize all of the other names. Okay. Alan Mawela, sorry. Alan Mawela. Are you new? They just indicate in the chat function for me if you are new. Okay, in the meanwhile, I will continue. Okay, let's look at transformative justice. Let's look at the aspect of transformative justice. Okay, and all the transformative measures taken to eradicate the social and economic injustices of the past, okay, encapsulate the theory of restorative justice. Okay? Now, in terms of this theory of restorative justice, okay, the justice system aims for an aspect of reconciliation rather than retribution or punishment. Okay, so the focus in addressing the injustice of the past dispensation. Okay, that is one of the reasons, okay, students, in terms of this transformative justice outlook. Okay, that is one of the main reasons that we had the Truth and Reconciliation Commission. Okay, because the aim of that commission was more reconciliatory, okay, than retributive. Okay, more reconciliatory in nature instead of retributive. Okay, so those of you, I normally there's a book by the author Ankie Krog, okay, which she wrote when she attended as a journalist the Truth and Reconciliation Commission hearings. Okay, that book's name is, let me just Google it quickly. Give me a second, I'm just Googling it quickly. It's called just see what book this is of Ankie Krog. Um, I have worked. Okay, I'm going to try and find the it's called Country of My Skull. Okay, I think that is the book I read. Nee? It's called Country of My Skull by Ankie Krog. Okay, those of you who have the opportunity to read that book, okay, read it because it gives you insight of what happened in the Truth and Reconciliation Commission. Okay, it gives you insight. Now, another on restorative justice, students, is that certain aspects of restorative justice currently is used in our criminal justice system, especially related to those non-serious crimes like petty theft, assault common, malicious damage to property. So in terms of that, the prosecutor, okay, or the perpetrator would request restorative justice, a restorative justice outcome, okay? And currently in that form, it's based on a mediation process. So, and mediation forms part of our branch of law of alternate dispute resolution, okay, ADR. And in terms of the mediation process, consent from the victim is required for such a process to be initiated. Okay. Well, the other thing I can say about restorative justice is that it has not yet, it hasn't been formalized in our legal system yet. So it's still very basic, it's still very informal, and we are still waiting on a legislative outcome or a legislative basis for the aspect of formal restorative justice. Okay. The person, someone is disturbing me. Yes. Bandile Masango, I'm removing you from this group. Ne? Okay. Here's a comment from Michelle. Yes, Country of My Skull. Okay, that is the book. So if you're able to read that book, please do so. Very insightful. Michelle, is that the link you're putting on?
Advocate. No, I was just Googling it and then I was trying to see if it's available at our libraries, but I didn't get that far.
Okay.
So I just put the
Okay.
name there.
Thank you.
Yeah.
Okay, let's continue. I'm going to page 163, and students, the concept of Ubuntu. Okay, it's the African concept, or best I can describe it, the African concept for humanism, to act with humaneness and to act with kindness. Okay, and this concept of Ubuntu has found our way into case law. Okay, so this is very, very important for you to know. You will definitely get questions on this. Okay, so the African philosophical concept for humanism and kindness, okay, has found its way into our modern case law. Okay, and this was in the Constitutional Court judgment of S versus Makwanyana. And you should know by now, as legal scholars, the significance of S versus Makwanyana. Why? Because that case essentially put a prohibition or a ban on the death sentence. Okay? So, okay, it tells you as part of the introduction on page 163, okay, that in any discussion on transformation and reconciliation, mention must be made of the concept Ubuntu. Okay, and what does Ubuntu mean in its literal sense, students? Okay, in its literal sense, it means that a person is a person because of others. Okay, now let's see how Justice, Constitutional Court Justice, she is retired now, but Constitutional Court Justice Yvonne Mokgoro, how she described Ubuntu as part of her judgment in terms of S versus Makwanyana. Okay? And she stated that generally Ubuntu translates to humaneness, okay? And in its most fundamental sense, okay, if you take it to its core, okay, it translates as personhood and morality. Okay? Metaphorically, it expresses itself, okay, describing the significance of group solidarity, on survival solidarity, compassion, respect, human dignity, okay, conformity to basic norms and collective unity. In its fundamental sense, it denotes humanity and morality. Okay? its spirit emphasizes, and this is where it had relevance in S versus Makwanjana. Its spirit emphasizes, very, very importantly, respect for human dignity, marking a shift from, okay, and it speaks from the past to the present, marking a shift from confrontation to conciliation. And here's the most important part of it, students. In South Africa, Ubuntu has become a notion with particular resonance in the building of democracy. Okay? So, it tells us, very, very simply put, okay, the African world outlook that one only becomes complete when others are appreciated, accommodated, and respected. As such, the concept is closely connected to transformative constitutionalism and transformative justice, which aims to address the injustices of the past. Okay, so this part on page 163, please know it verbatim. You are going to get tested on it. And let's look at the notes. Okay, let's look at this note. It tells you, in contrast with the interim constitution of 1993 that included the concept of Ubuntu, it is not explicitly mentioned in the 1996 constitution. Okay, but what has happened is our South African courts have, however, in a number of cases, applied this concept in their interpretation on the Bill of Rights. Okay? Any questions for me? Any questions for me? Just see if there's questions. Okay, no
Good evening,
questions.
Advocate.
Angelina,
How
I
are you
was
doing, Felicity?
wondering, I'm good. I was wondering when you were going to make your appearance.
I'm here. I'm here.
What is your question?
Just out of curiosity, is there a reason why it was excluded in the 1996 Constitution, whereas it was mentioned in the interim Constitution? If it is, if our constitution was solely based on the concepts of Ubuntu, shouldn't it be in our preamble or somewhere in our Bill of Rights? Advocate, are you there?
I'm here. Okay, so the concept of Ubuntu, if you read your founding provisions, okay, if you read your founding provisions, okay,
Yes.
your concept or your values of Ubuntu is encapsulated in that. Okay, so just read your founding provisions, and once you make sense of it, you will notice or you will appreciate that Ubuntu is encapsulated in them. Okay?
Okay. I
I
will go
told
through them
you,
again.
I remember your founding provisions are sections 1 to 6 of the Constitution.
Yes.
Okay? And it tells you, if you read the note on page 163, okay, it tells you that although it's been included in the 1993 Constitution, it tells you it is not explicitly mentioned in the 1996 Constitution. Okay? But although it's not explicitly mentioned, it is implied. Okay? Do you understand what I'm saying there?
Yes, sir.
Okay?
I just
It's
thought
not
maybe because
explicit, but it's implied. So once you familiarize yourself with the founding provisions, okay, you will see that it is definitely there.
yes, the fundamentals are mentioned there in the founding provisions of Ubuntu.
Yes.
Okay.
Yes. Okay. And remember, in our case law, it's stated that Ubuntu has become a notion in terms of building democracy and also in its fundamental sense, it denotes humanity, morality, okay, and the spirit that emphasizes the respect for human dignity, okay. And you will read in the founding provisions, it speaks of aspects such as human dignity, okay. So, although it's not expressly there, okay, it's implicit. Does it make sense?
It makes sense. Thank you, Advocate.
Okay. Um, any other questions? Okay. So if there's no other questions, okay. Angelina. Angelina, are you there?
I'm here, Advocate.
Okay. Turn to page 164.
I'm on it.
Okay. And it tells you there, okay, the preamble of the Constitution. Okay. It's filled with Ubuntu because it says, we, the people of South Africa, recognize the injustices of our past, honor those who suffered for justice and freedom in our land, respect those who work to build and develop our country, and believe that South Africa, and here it comes to the democracy part, okay, believes that South Africa belongs to all who live in it, united in our diversity. Okay, and the last part, okay, heal the divisions of the past and established a society based on human values, social justice, and fundamental human rights. That is Ubuntu.
Yes, it is.
Okay, so I hope that answers your question.
It
Okay,
does. Thank you so much, Advocate.
okay. So let's now let me just see if there's no other questions aside from Angelina's. Okay, let's move to paragraph 7.4.2 and let's look at the special features of the 1996 Constitution. Okay, this part you can also mark as in the special features. You will be tested on it. Okay, students, the special features of the 1996 Constitution are as follows. Okay, okay, are as follows. It tells you, okay, that the Constitution, you must know, okay, is the foundation of our democracy, okay? And our Constitution has 5 special features. Please be mindful that our Constitution has 5 special features, and we're going to go through all of these features. Many of them you know, so some of them I'll go through very quickly. Okay. And the reason why our Constitution has these special features, you must know there's a reason behind it. And the reason behind it is to ensure, very, very importantly, students, that the South African democracy succeeds. Okay? That is the fundamental reason why these 5 special features are built into the Constitution. Okay? For the primary reason to ensure that our South African democracy succeeds. So the first feature is the supremacy of the Constitution. Okay? So, students, before the Constitution, okay, what was the rule of South Africa like? Okay, what before constitutional supremacy, what laws, what was supreme in South Africa? Okay, what was supreme in South Africa before the advent of the Constitution? Hmm? Anyone? Very good, Michelle. Parliament was supreme. Okay, so it meant all the power of this country was vested in Parliament. And who was the head of Parliament? Huh? Who was the head of Parliament? Who was the head of Parliament at the time? Students? Who was the head of Parliament at the time? Who was the head of Parliament at the time? Anyone? Who was the head of Parliament at the time? The President. Very good, Michelle. Okay? The President was head of Parliament at the time. Meaning, most of the country's power was vested in Parliament and exercised by the President. Okay? So, the first special feature of our Constitution is supremacy of the Constitution, meaning that in our founding provisions, it states that our Constitution is the supreme law of South Africa. Therefore, everyone, including the President, every organization or institution, including all government institutions as well as organs of state, as well as all law, okay? All our law. And here all our primary sources of law are cited, meaning legislation, common law, as well as African customary law, are ruled and subject to the Constitution. Okay? And very, very importantly, from the supremacy of the Constitution, we need to familiarize ourselves with the notion of the rule of law, because the rule of law stems directly or flows directly from the supremacy of the Constitution. And this notion tells us that the law applies to everyone equally. Okay? And it's known as the rule of law. I'm on page 165, and it tells you very, very clearly that in our past dispensation, this was now before the adoption of our interim and our final constitution, Parliament was supreme or sovereign. Okay? In the sense that it could make any law it wanted to, no matter how unjust or unfair, as long as the correct procedure was followed. Okay? Meaning our courts did not have authority to question such legislation. Okay? Okay, students. So if we go to the note in the middle or almost at the bottom of page 165, it tells you that the Constitutional Court has the final say on the constitutionality of legislation. This means whether legislation is consistent with the Constitution or not. However, the Constitutional Court will then task Parliament to change or remove legislation in accordance with the decision of our Constitutional Court. Okay? Okay? Very, very importantly, students, and you will be questioned on this aspect, so you can highlight it. The Constitutional Court may not change or remove the legislation by itself, as this is within the powers of Parliament. Okay? Hence, this forms part of our doctrine of separation of powers. Okay? So now we go over to our second special feature of the Constitution, and this speaks of the doctrine of separation of powers. Okay? So, in our law, the state's powers are separated and divided into three different branches or organs. Okay? So, in South Africa, the power of the state is divided into three clear, distinctive branches. Okay? And here we're referring to three branches. Okay? Firstly, we have the legislative authority that makes our laws. That is Parliament, and specifically the two houses of Parliament, known as the National Assembly and the National Council of Provinces. Okay? The second branch of government is the executive authority that applies and carries out the law. Okay, the executive consists of the president and his or her ministers and deputy ministers. Okay, that is the executive. And the judicial authority, okay, judicial authority or judicial power in South Africa is vested in our courts, okay, and the head of the judicial authority, okay, the head of the judicial authority is our Chief Justice, okay, our Chief Justice, Justice Mogoeng is our Chief Justice, okay. So this is known as the separation of powers, and it stems from the common law doctrine known as the doctrine of separation of powers. Okay, and the separation of powers is essential in a democratic state. Okay, why? Because students, if too much power is concentrated in any one branch of state, this may easily lead to abuse. Okay, so by giving certain specific functions to each of the three branches of government, the separation of powers ensures that the powers of each state organ are kept in check. Okay? Are kept in check. Okay? Any questions on special feature number 2? Any questions on special feature number 2?
Hi, Advocate. Me again.
Michelle.
Yes. I was just thinking about the separation of powers and the authority that the president has to fill the positions of the constitutional court. For me, it just seems that he exercises his power there, so there's some level of control there. They can almost exercise some control over who's appointed there, so that's sort of in the favor of the...
No, remember, the president acts on recommendations only. Okay, so in terms of the appointment of, for instance, judges, okay, that is why we have the Judicial Services Commission, who is made up of various parties, okay, and their responsibility is to ensure that the best candidate is chosen for a position and that those candidates are recommended for appointment by the president. So the president is not directly involved in that process. The president acts on recommendations only. So that is how the president's
the checks
power
and balances.
is kept in check, okay, in terms of the Judicial Services Commission. Okay?
Okay,
Got
thanks.
that?
Yes, got
Okay,
that.
Michelle? Okay. Any other questions, students? Any other questions? Okay. If there's no other questions, we continue and let's go to special feature number 3, which speaks to the structure of our courts. Okay. So the Constitution, our final Constitution, sets out the structure of the judiciary and our judicial system. Okay, so you should know by now that the power of the judiciary is vested in our courts, students. Okay, and our courts are divided into two types of courts. Our courts are divided into two types of courts. Who can tell me what those two types of courts are? Okay, our courts are divided into two types of courts. Who can tell me what those two types of courts are, students? Who can tell me what those two types of courts are? Thank you, Nail. Superior courts and lower courts. So in terms of our court structure, our courts are divided into two types of courts, namely superior courts and lower courts. Okay, and in terms of our superior courts, we have three types of superior courts.
Advocate, you are
Sorry,
on.
I've broken up there. I'm sorry, I've broken up there. So we have three types of superior courts: our Constitutional Court, our Supreme Court of Appeal, and our High Courts. Okay, we have lower courts, which are divided into our magistrates' courts, and our magistrates' courts are divided into two types of courts based on the jurisdiction, okay? Divided into regional courts and district courts, okay? Then, please be mindful, know this, that our superior courts have the power known as inherent jurisdiction, okay? Inherent jurisdiction. So if we go to our Constitutional Court has the final say in constitutional matters, okay? And that relates to any issue, okay, that involves the interpretation, protection, or enforcement of the Constitution. Okay. This means that the Constitutional Court can decide that Parliament must change or remove legislation if that legislation is not consistent with the Constitution. Okay. Very, very importantly, the Constitutional Court can also make the application or enforcement, okay, by the executive branch of government of a law invalid, okay, if such application or enforcement is inconsistent with the Constitution, okay. Our High Court and Supreme Court of Appeal may also hear constitutional issues, but the Constitutional Court has the final say in these matters. Okay? So the Constitutional Court is the final court that one is able to appeal to in a constitutional matter. Okay? So in terms of Section 167.5 of the Constitution, the Constitutional makes the final decision on whether legislation is constitutional or. Okay?
Hi,
And
Advocate.
Angelina, give me 1 second.
Okay, sir.
Michelle, this is what I spoke to you about earlier. Therefore, if a High Court or Supreme Court of Appeal makes an order that certain legislation is unconstitutional, such an order will only have force if it's been confirmed by the Constitutional Court. Okay, Angelina?
Hi, sir. I just wanted to find out, was there ever a case where the Constitutional Court's decision was challenged, and is it possible to do so?
It cannot be challenged. It's a court of final instance, so it cannot be challenged.
So nobody can challenge it.
No one can challenge it. Cannot be challenged.
Okay.
Yeah?
Okay.
So no, cannot. It's our highest court. It's our apex court. It's our supreme court. It's our supreme power. Something supreme cannot be challenged. Yeah?
Okay.
Okay.
Thank you.
Sorry, can
Okay.
I feel the same way as Angelina about that, about the Constitutional Court having all that power vested in 9 people, and that it cannot be challenged.
Michelle, is that you?
Oh yes, sorry, it's me.
Michelle, that is how our judiciary is structured. Okay? And that is where in my view, the judiciary, and when I look at the Constitutional Court, most of our power is vested in that court because that court has the final say over any matter.
But it's the interpretation of the Constitution. So the weight of the Constitution rests in their decision-making ability and how they've interpreted. Because if I read some court cases where they've overturned maybe 1 or 2 decisions down the line, then one actually wonders about that. But it just seems as if there's a lot of power, like a supremacy of the judiciary, more so than the supremacy of the Constitution.
There's lots of power vested in those Constitutional Court judges. You are right. Okay, that is why the appointment process is so strenuous, because it is people of the highest character that are appointed as Constitutional Court judges, because there is such a huge responsibility on them.
Yeah.
Okay, so you guys are right. There are lots of power vested, especially in our Constitutional Court. I'm glad that you're realizing it. Okay, but that is our law. Okay, currently it's good law, cannot be changed. Okay, so can I continue? Okay, let's go to special feature number 4. Okay, special feature number 4. Okay. Special feature number 4, which I regard as a very important feature, speaks of the state institutions supporting democracy, meaning these are our Chapter 9 institutions. Okay, so our Chapter 9 institutions very, very important because a number of them were set up to support and protect, very, very importantly, support, protect, and promote. Okay? It's not only support, protect, and promote our constitutional democracy. Okay? And these institutions are the Public Protector, the South African Human Rights Commission, the Commission for the Promotion and Protection of the Rights of Cultural, Religious, and Linguistic Communities, the Commission for Gender Equality, the Office of the Auditor General, the Electoral Commission, as well as the Independent Authority to Regulate Broadcasting. On page 168, very importantly, students, very, very importantly, these institutions are all independent, okay? Meaning they only report to Parliament, okay? They are only accountable to the Constitution and to Parliament. And their function is to protect the people from abuse of state power and to make sure government does its work properly. Okay? Any questions related to that? Any questions related to that? Let me just see if there's any questions related to that. Okay, no questions so far. I will go on to our last special feature number 5, and this is our Bill of Rights. Okay. Special feature number 5 is our Bill of Rights. Okay. And our Bill of Rights is Chapter 2 of the Constitution. Okay. Our Bill of Rights is Chapter 2 of the Constitution, and here the purpose of Chapter 2 is to protect the fundamental rights of each person. Okay? The fundamental rights of each person. Okay? We're going to speak on the Bill of Rights more in detail in learning unit number 8. Okay, students, are there any questions? Are there any questions for me? Okay, if there are no questions, I want us to go to, hold on, to page, is it 173, paragraph 8.4, and we're going to look at the categories of fundamental rights. Okay? Let's look at the categories of fundamental rights. Okay, so our fundamental rights have been divided into three categories. Okay, first generation rights, second generation rights, and third generation rights. Okay, so our first generation rights, known as our blue rights, okay, known as our blue rights, consist mostly out of our civil rights, procedural rights, and political rights, meaning these rights are those rights that protect the individual from the abuse of state power, okay? And here we're looking at the right to equality, the right to human dignity, the right to life, freedom of expression, the right to freedom and security. Okay, so we're looking at those types of rights. Um, our second generation rights, okay, also known as our red rights, okay, they relate to our social economic rights, okay, and it's issues which concern um, our society and the economy, meaning these rights allow people to demand that the basic socio-economic rights be examined and dealt with by government. And examples of these rights are the right to education, access to healthcare services, and sufficient food and water. Okay, and then lastly, we're looking at our third generation rights, also known as our green rights. Okay, now these rights have less to do with the individual and more to do with a group. Okay, and here we are looking at issues like um, clean and unpopulated air. Okay, so how our rights are categorized into three groups, that is very, very important, and you must know it, students. Okay, very, very important, and you must know it. Okay, and what is the time now? I'm going to work at least for about, let me just see here. I'm going to work for at least about 10 more minutes. And now we will look at the nature of fundamental rights. We will look at the nature. Sorry, students, I didn't realize I was on mute. Sorry, I didn't realize I was on mute. Okay, let's look at the nature of fundamental rights. Okay, so if we look at what a fundamental right is, if we look closely at some kind of definition, students, okay, it tells us that a fundamental right is that right, okay, that every person has simply because they are born. So it means every person is born with human dignity, and this human dignity gives a person a claim to human rights, meaning that you do not have to work for these rights or qualify for them, as they are your natural rights. In other words, they are fundamental to each human being, as we are all born with these rights. Meaning that because each person has these fundamental rights, the state can never take them away. Okay? But you should realize also that all rights are not absolute. Okay? All rights are not absolute, meaning that in some cases, these rights may be limited in terms of Section 36 of the Constitution. Okay? So, if you look at Section 7, the Bill of Rights starts with Section 7. It tells us the Bill of Rights is the cornerstone of democracy in South Africa. Okay? It enshrines the rights of all people in our country and affirms the democratic values of human dignity, equality, and freedom. And look at the next important aspect, which tells you that the state, the word must is used, so it's peremptory. The state has no choice or no discretion. Okay, the word must is used. The word must is used, meaning that the state must respect, protect, promote, and fulfill the rights in the Bill of Rights. Okay, you got that? You got that, students? Okay, so I want you to, on your own, go through the vertical as well as horizontal application of the Bill of Rights. Okay, so what I'm going to do is I'm going to conclude here for tonight. I'm a bit tired tonight, so I'm going to conclude here for tonight, and then I'm online tomorrow night again. Okay, so if there are any questions, I'll answer one or two questions quickly. But other than that, I am ready to conclude for tonight. So, students, before I conclude, are there any questions for me?
Hi, Advocate.
Yes, Angelina.
Yes, sir. Saturday morning. Are we seeing you for ILW or for PVL?
You seeing me for PVL,
Mhm.
ILW, and skills.
All in one.
Okay, all in one. All in one. Let me give you the time. Okay, so let me give you the time.
You're on mute, advocate.
Okay, let me give you the time slots quickly for Saturday. Okay,
Okay.
so Saturday morning, okay, we will start from 9 to 11 for law of persons. Yeah?
Okay.
And then from 1 to 3 for ILW. Okay, and then from 5 till 7 for skills for law students. Yeah? So those are the time slots for Saturday.
Okay. Is it gonna be on the normal links or is Miss Black gonna send us new invitations?
It will be on the normal links.
Okay.
Okay.
Thank you.
Okay. Okay, students. So if there's nothing else, I'm concluding for tonight. I will check tomorrow which students have logged requests for individual sessions, and I will make contact with you tomorrow. Okay,
You owe me a session,
students.
advocate, by the way. You haven't
I will make
responded.
contact. I will make contact with you tomorrow. Yeah?
Thank you, sir.
Okay, Angelina. Bye.
Cheers. Good
Bye,
night.
all
Bye.
of you. Bye.